The first case to come before the court this morning is Christopher A. Scala versus William A. Scala. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. Attorney Reed, when you get started, if you could let me know if you'd like to reserve any of that time for rebuttal. I am keeping the clock and can keep you apprised of the passage of time. Please don't use the names of any minors or victims as we are recording this and it will be posted on our YouTube channel. I don't really think that's relevant to this case, but we always like to issue that advisement. We have read the briefs and we are ready to proceed when you are.
Your Honor, appellant is ready. Good morning, Matt. May it please the court, counsel. We are here today asking this court to reverse the judgment of the trial court, denying a motion for summary judgment, that partial summary judgment that we filed on behalf of Christopher Scala, and to reverse the decision of the trial court granting summary judgment across the board against Christopher Scala on all causes of action, suggesting that there is no genuine issue of fact and that defendant William Scala is entitled to judgment as a matter of law. I am, for the record, Orville Reed, one of the lawyers who have represented Chris in this case. Along with me today, David Birch, my partner, who has also been actively involved in this case. My secretary, Bonnie Miller, who will handle any technical difficulties we experience. Hopefully we'll have none, but we're incompetent to deal with them. And also Craig Marshall, as well as Christopher Scala, the party plaintiff in this matter. Our motion for partial summary judgment was based upon the fact that no legitimate offer, no bona fide offer, no good faith offer was made by Mr. Michael Scala to the company as required by Section 1 of the agreement restricting the distribution of shares of Kenmore Construction Company, Inc. The basis of that contention is that it was not a good faith, not made in good faith. It's based upon the fact that prior to November of the year 2016, there were 3 shareholders. Michael Scala, who owned 1/3 of the company, Christopher Scala, who owned 1/3, and William Scala, the CEO, who also owned 1/3. An agreement had been made between Michael Scala and William Scala that he would sell his shares of stock pursuant to the 3rd Amendment to William Scala. That was made between the two of them. When it came time to make an offer to the corporation, to the company, the offer was made that he offered to sell his shares as he was required, mandated by Section 1 of the agreement. Mr. Scala said he would sell it, and Mr. Christopher Scala voted in favor of that. Mr. Scala has a conflict. He's already promised to sell these shares to William, and he was not at liberty to even offer them to the opposing side, to Kenmore. The point is this, that this was not a good faith offer made pursuant to Section 1 of the agreement. Not only did he intend to sell his shares of stock and announce that to William Scala, but he voted against his very offer being made to the company. This is not good faith. In Judge Painter's decision, noted jurist from Hamilton County, in the case of Little John versus Parrish at 138 Ohio Ave 3rd, Judge Painter makes the observation that in Ohio, there is a good faith obligation on the part of every party to a contract to faithfully carry out the terms of the obligations of the contract. That did not happen. He had already promised to sell these shares to William and voted against the corporation buying those shares. And he did it because in Michael's mind, apparently, he believed that if he did that, there would be a 50-50 standoff, deadlock between Chris and Michael. Excuse me, between Chris and William. Okay, in response to the question of good faith, it's clear that he did not act in good faith. There are consequences to the failure to comply with Section 1 of the agreement. Section 1C of that agreement provides that any effort not to comply with the terms of Section 1 results in the agreement being rendered between William, the transfer, null and void. It's a dire consequence. But in this case, it's a dire consequence in the sense that William received no stock from this transfer, and also that the dominoes begin to fall. For example, on the basis of his acquiring what he believed was 2/3 of the shares of the company, 4 months later, 4 months after this debacle of the proposed offer to the company, William enacted the Fourth Amendment. And in the Fourth Amendment to the agreement, he set out and enacted this by himself because now he purported to own 2/3 of the company. He sets out to destroy an agreement that had been made when the parties entered into this contract in March of 1990. This agreement had been in effect from March of 1990. No one bothered to change Section 1. The parties accepted that. Michael and William violated that. William gets nothing out of that sale. Nevertheless, purporting to own 2/3 of the company, William then enacts the Fourth Amendment that destroys Chris's right to receive Section 6 value for his stock when he dies. That was a guarantee that appeared in the original agreement that was executed by the parties, by all the Scala siblings, including Michael and Chris and William in 2019. They lived with that. Bill enacts the Fourth Amendment to the agreement that allowed, the original agreement allowed the person a guarantee, and that is at his death, his family could receive the Section 6 value of his stock. Up until then, there was no absolute right to have his stock purchased by the company or by any shareholder. But upon death, there was an absolute requirement that the company had to pay Section 6 value to Chris's family. He took that away. And he did it under the guise that the company couldn't afford to buy his stock out. It did more than that. He made an effort in Section 4 to destroy the value of Chris's stock. And he did this by imposing these restrictions on that stock. One, Chris could sell it to another party, but that party had to be approved by those who owned 60%. In this case, it's Bill. Also, the person who bought the stock had to sign on an agreement that he not only accepted all of the amendments and all of the terms of the original 2019 agreement, but that he would accept whatever agreements were made by the majority shareholders in the future. And considering what the Fourth Amendment did, it would be unlikely that any third party would come in and buy this at close to Section 6 value. Mr. Scala, William Scala, undermined the value of the stock and made his best efforts to make sure that Chris never received Section 6 value. They didn't act in good faith. Bill never got 2/3. There really is no Fourth Amendment. But if there was a Fourth Amendment, it is in violation of Crosby versus Beam, because it is the abuse of a minority shareholder by the majority shareholder. The court says, well, it's okay because the company couldn't afford to buy Chris out. There is absolutely no evidence in the record to establish that in point of fact, that was true. None. The court says this could happen, but there's no evidence in the record to establish that the company could not afford to buy him out based upon another section in the agreement that allows the court to change the calculus for determining valuation of a dead shareholder, or any shareholder for that matter. So if the company has a difficult time raising the money, they can, instead of using book value for the equipment, they can establish that fair market value should be used in determining and paying out the shareholder. Also, it's also true that under the agreement, the shareholder, sorry, I lost my train of thought. Well, let me move on. I'd ask the court to take a look at also at Section 5. Section 5 of the agreement addresses the failure to comply with notice in terms of a sale. And it addresses the issue in this way. It says, look, the failure to promptly give the notice as required does not void the sale. But it does not address what happens if someone does this in bad faith. Pursuant to the long-standing law in Ohio, that every party to a contract, whether it's a mortgage, whether it's an agreement to restrict transfer, regardless of what the contract is, the parties to the contract are bound to act in good faith toward one another. That did not happen here. There was no transfer of stock. Bill does not own 2/3 of the company. In fact, because of the violation, which is described in 1C, the shares of stock either go to the company or they go to Chris. So Chris, in fact, could own 66 2/3% of the company based upon this court's decision.
Counsel, I apologize if you mentioned this when you got started about reserving time. You have about 4.5 minutes left. You can continue or reserve. I apologize again if I missed it.
Your Honor, I did not, and I would ask to reserve 3 minutes. I apologize.
Certainly.
I've gone
No
on
problem.
too long. I would like to address one other issue. The court should have granted summary judgment on our motion for partial summary judgment, absolutely. And it should have determined that Bill does not own 66 2/3%. There is no Fourth Amendment because it was not properly enacted. The other point I want to address is the issue that goes to this transaction in Columbus involving the matter of Kenmore Aggregates and or the new name, which is K-Nova. K-Nova is a company that was a name change from a company known as Kenmore Aggregates. It was an affiliate of Kenmore, and in point of fact, Chris had a 1/3 interest in that business. As a result, Chris was entitled to participate in the venture that is underway now down near Columbus, Pickaway County, and he has been told he has no interest in this business. And that's based solely upon the fact that Chris, at the last minute, changed the name, not the structure of Kenmore Aggregates, but the name of Kenmore Aggregates to a company known as K-Nova.
And counsel, you're right at that 3 minutes.
Thank you, Your Honor. Your Honor, I used the term Chris. It was Bill that did this, and I apologize for the confusion. I apologize.
That's okay. Counsel for the appellee.
May it please the court. My name is Matthew Nacon, and I, along with my co-counsel Rochelle Zadar and Michael Nacon, represent the appellees, Bill Scala and the estate of Michael Scala. This case may have been filed primarily out of jealousy and hurt feelings, but it's not what this appeal is about. This appeal is about whether or not there is evidence in this record to raise a genuine issue of material fact on any claim, and whether or not Bill Scala and Michael Scala were entitled to summary judgment as a matter of law. Now, I'm here to answer any questions regarding any claim, but it is a massive record, as I'm sure the court has already realized. I'm not going to get to everything. After my initial comments on some procedurally dispositive matters, I intend to focus on assignments of error 2, 3, and 4, each of which pertain to the amendments and Mike's sale of his shares. Because Chris implicates the law of fiduciary duty, and Mr. Reed just made some pretty bold claims regarding the value of Chris's shares, I think it's important to note that it is undisputed in this record that since Bill became majority shareholder in the year 2016, the economic benefits that Chris has received from distributions and compensation have increased to the highest level in Kenmore's history. Chris has also admitted that he has not suffered any adverse employment decision. He has remained a shareholder, director, and officer of the company, and that it is Chris's opinion that Bill Scala receives too little compensation for the job that he does. That is simply not minority shareholder oppression, and it's certainly not minority shareholder oppression contemplated by Crosby versus Beam. Yet Chris tries to cram this case into Crosby. Importantly, Crosby is only a standing case, which is very limited on the issue of standing in applying only to breach of fiduciary duty claims when it comes to a minority shareholder. It has not been extended to protect a shareholder from his own agreements, and it has no application to any claim in this lawsuit other than the fourth assignment of error and the two breach of fiduciary duty claims that pertains to. This case has always been about Chris demanding that he be permitted to increase his ownership in Kenmore from 33 1/3 to 50%. In short, there is no fiduciary duty requiring majority shareholders to make minority shareholders equal. Yet Chris contends that even—
But that kind of begs the question, doesn't it? Because he only became a minority shareholder due to the actions that were taken by Bill. So that kind of begs the question as to what happened here. You can't say, well, you don't know the duty to minority shareholders to make them equal. But the point is, he's alleging you took away my right to begin with.
There is no question that first of all, it's not conduct just by Bill. It was 3 equal 1/3 shareholders, each of which voted on a motion before the board of directors. And
the one brother voted against his own motion, right, Steve?
Well, it's actually, and I believe it's Mike is the brother,
sorry,
Your Honor. And so that I can be clear about this, and Mr. Reed just focused on the presentment, what he's calling an offer. The shareholders agreement between the parties requires an opportunity. There's an option on behalf of the company to exercise the right to buy out a shareholder. It is an option every shareholder must present their shares to the board, and then the board determines whether or not to exercise that option. It's a presentment issue. Each shareholder has an obligation under the agreement to make the presentation. The duty then shifts to the board of directors, completely different role, shifts to the board of directors, and the board of directors votes on that issue as to whether that's in the best interest of the corporation or not. Bill and Mike clearly both voted against that. And while there's been some disagreement with this, the exact manner by which it happened, and Chris was not only in attendance, he recorded the meeting, the exact manner by which that happened is that Chris made the presentment. The offer was presented to the board. Chris made a motion to accept, and the board, the motion failed for lack of a second. Bill then made a motion to decline, and they declined. This issue about fraud is, and the case that Mr. Reed cited in his supplemental authority actually destroys their case. There is no fraud in whether a corporation chooses to exercise its option or not. Either the corporation, it's an option right. The board of directors decides whether to accept it. This illegitimate offer, if you look at every case they've cited, refers to what are called rights of first refusal, which are completely different than options. And in a right of first refusal situation, the shareholder must go out and obtain another offer, and then there's a different level of presentment. All the fraud cases they're talking about are rights of first refusal. The second problem they have with this claim, both on their motion for summary judgment, is they're already foreclosed from pursuing the second claim for relief in their motion for summary judgment, because if they were going to bring a claim on behalf of the corporation, it was required to be a derivative claim. Chris has no right to pursue a claim for an option that belonged to the corporation. The law on that is crystal clear. The thing that is important here in terms of some procedural issues is that there are several of the claims that have been advanced in this case for which Chris cannot pursue because he has given them up. So for instance, you heard some discussion here about the fifth assignment of error concerning the Fourth Amendment. Chris is barred from pursuing any claim under the Fifth Amendment because he failed to address the court's award of summary judgment on rightness grounds. The trial court awarded summary judgment on that claim on two bases: that the Fourth Amendment treated every shareholder exactly equally, and that the claims were not ripe for review. This discussion about there's some destroying of the value of Chris's shares. Chris holds exactly the same shares he always held. They have increased dramatically in value since 2016. There's no issue about that in the record. And as this court has held many times, most recently in Colville versus PNC, when a trial court grants summary judgment on multiple alternative bases, the appellant does not challenge one of those bases on appeal, the court will uphold the judgment on the unchallenged basis. They didn't even deal with the rightness issue. What Chris is attempting to argue, and understand what the Fourth Amendment did, it was an extremely limited, it changed what was a mandatory buyout under the shareholders agreement to a company option. That's all it did. That's it. And the reason it was done, and the record's replete with this, is Bill Scala, owning 2/3 of the company, had value of $25 million that was not covered by insurance. To place a $25 million obligation on the company if he died would have been harmful. Nobody said it would bankrupt the company, but a $25 million option was staggering. There's no change to what happened to Chris as a result of the Fourth Amendment. He has exactly what he had, and he continues to receive enormous benefits as a result of this. It appears that since it wasn't addressed, that the declaratory judgment action, this case started with the shareholders agreement and some language in the shareholders agreement that resulted from a drafting error. The 5 words signed by all parties remaining in section 15A. Mr. Reed didn't address that at all. And quite frankly, we would cite the court to the affidavit of Ruth Anderson and the deposition of Ruth Anderson as exhibits 11 and 12 to record 128, which are all of the summary judgment exhibits. The bottom line is Ms. Anderson makes very clear that exactly how this error occurred. It was a drafting error by Mr. Bartlow when he drafted the agreement. And there's no doubt that both under the what the court was obligated to do in this instance was assess where there's a conflict of terms which one apply. All of the rules of contract construction, specific provisions, control over the general, provisions appearing under a heading that suggest it was intended to apply, and more importantly, that they give effect to the agreement, all of those point to section 12. Frankly, the mountain of evidence that was put in front of the court in terms of extrinsic evidence was always that the shareholders intended the section 12B to govern amendments, and Chris offered no evidence.
Let me interrupt you for a second if you don't care.
Sure, Your Honor.
Let's say that the trial court was right in determining that the proper procedure was followed, okay, for Bill to buy Mike's shares and for Bill to become then the majority shareholder of the company. Okay, let's just assume the proper procedure was followed. How does that get rid of the fiduciary duty to do what's in the best interest of the company and the minority shareholders? Because the court ruled as a result of that,
Correct.
it got rid of the breach of fiduciary duty, breach of contract. And I'm not sure I understand that.
I'm glad to answer that question. It's primarily 2 ways. First, there's the way the claim was pled in count 2. is that, and what Mr. Reed just said, is that Chris held a vested right that once the agreement was put in place, it would never be changed. What the trial court was referring to and what is determinative of the issue from a fiduciary duty standpoint is first and foremost, whether or not there is a contract in place that was followed. And if Chris gave up the right to contract gave up the right to amendment by 60% of the shareholders being permitted to amend, and that was followed, Chris has lost that. You cannot assert a fiduciary duty claim as a result of that. Now, Your Honor, I think your question is actually a little deeper than that. Is then you have to look at Crosby versus Beam, not for the mere fact of amendment. Amendments decided by the contract. If the power's there, they have the right to amend. Chris, you have no vested right. However, if there's a contention that the result of the amendment is somehow unfair to Chris, or somehow Mike or Bill got a right that Chris did not get, the Second and Third Amendments clearly enunciate that they apply to all shareholders and all shareholders have an equal right. That this was done out in the open, and Chris was told every step of the way what was about to happen. In October 2015, the brothers tried to come to an accord on this issue because there was great fear of a 50-50 deadlock between two shareholders that A, don't get along, and the fact of the matter is Chris hasn't gotten along with most members of his family. It's kind of beside the point. You can't have them running a company. It wasn't until December of 2016 that the sale occurred, when the Second and Third Amendments were adopted in January. Chris had every opportunity under the Second Amendment, and the Crosby versus Beam analysis starts with, first and foremost, whether or not every shareholder has an equal opportunity. It is an objective analysis. It's not subjective, meaning every one of these shareholders had the transfer rights were changed so that Chris could have bought out Mike. All he had to do was go to him and make a better offer. The difference is that for Mike, it wasn't monetary. And so what Chris is complaining about is that he didn't have the relationship with Mike. He didn't have a subjective opportunity. The Second Amendment, the very first analysis under the first element of Crosby versus Beam, is whether it impacts all shareholders equally. Every shareholder had the exact same right. Then it goes to the second question, is there a legitimate business interest to do that? And clearly, the trial court found that preventing a deadlock from two shareholders that do not get along for a multi-million-dollar company is a legitimate business interest. So that's the answer to your question, Your Honor. They're actually two separate issues. It's dispositive of the issue of whether the amendment could take place in the first place. Then when you look to the issue of whether or not the amendment applied to all shareholders equally, it absolutely did.
And counsel,
So-
you have about 20 seconds if you'd like to wrap up. I know the time goes quickly.
It does go quickly, Your Honor. In my last few seconds, I would urge this court to review the 2020 decision of the First District Court of Appeals in Moss versus Moss, which dealt with similar allegations of breach of a fiduciary duty, usurpation, and misappropriation of family business, upholding an award of summary judgment. And lastly, I would urge this court to review the detailed summary judgment record, as appellees want this court to see the record. It is very well developed. Your Honors, may I conclude?
Quickly, yes, thank you.
For these reasons, as well as those detailed in appellee's brief, appellees William Scala and the estate of Michael Scala respectfully urge this court to affirm the grant of summary judgment to appellees in all respects and deny appellant's cross appeal. Thank you, Your Honors.
Thank you, counsel. Attorney Reed, I gave Attorney Nacon a couple more seconds, so you're going to have your full 3 minutes of rebuttal.
Thank you very much, Your Honor. And
Even it
thanks for
out.
helping me out on the time. Your Honor, first of all, Crosby is more than a standing case. It is a case that requires the majority shareholders to act in the utmost good faith and loyalty and fair dealing and fair play with minority shareholders. It is more than standing. And in point of fact, standing is what enables Chris as the minority shareholder. He's been personally harmed by the decisions made by William in his capacity as a 66 2/3% owner. And he has been harmed. As a matter of fact, Judge Quillen, a noted jurist from this district, in the Gensimer case, Judge Quillen said this. He said, we don't have to bring a derivative case where it's one partner against another partner. A derivative case is brought when there's going to be a multiplicity of lawsuits. That's what it's all about. It's to prevent a multiplicity of lawsuits from various shareholders. This is not that case. There is one shareholder who has been harmed, and he has been harmed by Bill and Mike, and he has been harmed and has the right to bring this case on his own for the losses that he suffered. Secondly, I'd like to address something Mr. Nacon said. He said the court found this, the court found that. That was not his job on summary judgment. That's for the jury, for goodness sakes. Everybody knows that. The court acted as judge, jury without a trial. He looked at the evidence, made findings, and said, this case is over. There's no genuine issue. I don't believe they acted in bad faith. I don't believe they did this. I don't believe they did that. That's not for him. Credibility belongs to the jury. Preponderance of the evidence belongs to the jury. Those are jury issues. This is outrageous what has happened here today. And then Mr. Nacon would cite the court saying, he found this. That means nothing. That means nothing. That was not his job to be a finder of fact. First of all, in terms of ripeness, I guess what the court was saying when it said ripeness is that Chris hasn't died yet, so he has no right to complain about the Fourth Amendment. Chris, I hate to tell you this, you are going to die. We're all going to die. To say that he doesn't have any rights because of ripeness is to the point of absurdity. The court overstepped its bounds in making findings of fact. As a matter of fact, it determined that they were acting in good faith when they sought to prevent Chris from being a 50% shareholder. That's outrageous. That's up for the court to decide, the jury to decide what is and what isn't good faith. Look at the Gadamian decision and also Sun Pacific, which is a case that I did cite to you in a supplemental submission that was made recently in May of 2010 by the Sixth Circuit. There they said, states of mind, issues of good faith, those are properly before the jury. They're not for the court to decide on a motion for summary judgment.
And counsel, I need to let you know that you have utilized your 3 minutes, and the court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties as well as posted on the Ohio Supreme Court website. Thank you both for appearing via Zoom today. Enjoy the rest of your day. Thank you.
Very